Oh, rural landowners often receive payments from companies for rights of way or easements over their property. However, the various type of payments need to be reported correctly to avoid any potential tax consequences. Our good friend Roger McEowen with the Washburn School of Law joins us now for more on this issue. And it's so much information, typically hard for the average person to navigate. So always a pleasure to have you here. So walk us through some of the most common types of payments, Roger.
Yeah. Thank you, Suzanne. Good to be with you. And you're right, it does get complicated quickly. Well, you might have a bonus payment, which is what a company would pay in advance to come in and have rights to the property, to take measurements, to see if what they want to do, put a line through or drill or whatever the case might be, whether your property is appropriate for it. And those bonus payments should be reported on Schedule E, and therefore they're not subject to self-employment tax. There might also be damage payments, and damage payments to crops, damage because of soil compaction. Well, you might be able to offset the payment you receive by your income tax basis in the land that's affected by the easement damage. But payments for growing crops, there's kind of an exception for those. Those are treated as a sale of the crop, and that's on Schedule F for a farmer. Form 4835, if you're a non-materially participating landlord, or Schedule E if you're a cash rent landlord. Then there might be severance damage. And if they're specifically delineated in the contract that you sign, those might qualify for involuntary conversion treatment. If they're not specifically identified, they're just damage payments. And then there also might be a payment for a temporary easement, maybe to store some products on the property while you are constructing your pipeline or your energy line, or using the easement to get it started. And that would just be simply rental income.
What about payments that farmers received under a lease agreement? Are those treated differently?
Yeah, those are payments for a definite term, and those are rental income. There's no basis offset on those.
Can eminent domain procedures ever play a role in that matter at all?
Well, they certainly can, and the funds can be used to buy replacement property under the involuntary conversion rules, and that might allow the landowner to defer the reporting of the income until the replacement property is sold down the line, if it ever is.
So, Roger, overall, what do rural landowners need to know? What's the overall, they walk away with understanding how they go ahead and file?
Yeah, well, this is a pretty common issue in certain parts of the country. There are a lot of lines that are crossing Iowa. Iowa seems to be kind of the center point for distribution channels to get through, whether it's a pipeline, whether it's a carbon line, whether it's an electric transmission line. But I think the message is get good tax counsel before you do a deal. This can get complex quickly, and the tax consequences can be enormous with the right set of facts. And you want to make sure you're on top of and understand what it's going to do to your tax picture overall before you get into a deal.
Absolutely. Great advice. Know what you're doing before you sign anything. Roger McEowen, always a pleasure. So smart with the Washburn School of Law. So appreciate you joining us.